From the nation's capital, the American Enterprise Institute for Public Policy Research presents Public Policy Forums, a series of programs featuring the nation's top authorities presenting their differing views on the vital issues which confront us. Today's topic, a constitutional convention. How well would it work?
The politicians and the pollsters these days all seem to agree vast numbers of Americans want the federal government to stop its deficit spending and balance the budget. Some want it done through congressional legislation. Others are insisting that it take the form of a constitutional amendment ordering Congress to balance the budget. Some balance the budget amendment advocates say the best way to achieve this goal is through a constitutional convention, similar, they say, to the only one ever held in this country in 1787 when the Constitution was written. But there are no rules written down about this, not even any guidelines for such a convention. So among the questions being asked are these. How would convention delegates be chosen? Under what rules would it operate? Can it be limited to just the budget balancing issue? Or could other proposed amendments be debated, such as school prayer or anti-abortion amendments? There are warnings that a runaway constitutional convention might even go so far as to limit free speech or establish a national church. And how, they ask, would such an amendment be enforced if a future Congress decides not to pay any attention to it? Welcome to another Public Policy Forum, presented by AEI, the American Enterprise Institute, a nonprofit, nonpartisan research and education organization. Today's roundtable discussion will consider the topic, a constitutional convention. How well will it work? Appearing on our panel today are Paul Bator, a member of the Harvard University Law School faculty since 1959. Professor Bator once served as law clerk to the late U.S. Supreme Court Justice John Harlan. He has been a visiting professor at Stanford and at the University of California at Berkeley. He is currently visiting professor at the University of Chicago. Walter Burns, a resident scholar at the American Enterprise Institute. Dr. Burns, who is a political scientist, has taught at Yale, Colgate, Cornell, Louisiana State, and the University of Toronto. At AEI, Dr. Burns is chairman of the Advisory Council on a project entitled A Decade of Study of the Constitution. Gerald Gunther is William Nelson Cromwell Professor of Law at Stanford University Law School. Professor Gunther once served as law clerk to the late Supreme Court Chief Justice Earl Warren. He has taught at Columbia and Harvard universities. Professor Gunther is author of the publication Cases and Materials on Constitutional Law, now in its 9th edition, the most widely used constitutional law book in the United States. Antonin Scalia is a professor at the University of Chicago Law School. As with panelists Gunther and Bator, he too is a Harvard Law School graduate. Professor Scalia once served as Assistant Attorney General in the Office of Legal Counsel. He was General Counsel in the White House Office of Telecommunications and served as Chairman of the Administrative Conference of the United States. He is an AEI adjunct scholar. John Charles Daly will moderate today's program. Mr. Daly is a former head of the Voice of America and has been a news correspondent and news analyst for CBS News and for ABC News, where he also served as a network vice president. Now, here is Mr. Daly.
This Public Policy Forum, part of a series presented by the American Enterprise Institute, is concerned with the prospect of a constitutional convention to propose amendment of the United States Constitution. The first convention since the original in Philadelphia in 1787, which scrapped the Articles of Confederation and substituted our present Constitution. Our subject, a constitutional convention. How well would it work? 30 states have now taken the extraordinary step of asking the Congress to call a constitutional convention. In the words of Article 5 of the Constitution, if 4 more states petition, the required 2/3, quote, Congress shall call a convention for proposing amendments. Does the language of Article 5 mandate a general convention to propose such amendments as the convention wishes, or does it permit a convention to be severely limited to the specific issue or issues proposed in the petitions from 2/3 of the states? While petitions for a constitutional convention to consider other specific issues have become before the Congress, the focus now is on 30 petitions requiring a balanced federal budget, except in times of national emergency. The chairman of the Senate Budget Committee, Maine's Edmund Muskie, says of the 30 petitioners, they have lost their grip on the enormity of what they are doing, and they have taken the wrong way out of a troublesome dilemma. It is an uncharted course to an unknown destination. But we are not here concerned with the economic questions in the balanced federal budget amendment. Our primary interest is the uncharted course, the fundamental constitutional questions and potential political confrontations raised by the petitions from the states. Professor Gunther, you have described the road to a constitutional convention as foggy and treacherous, beset with many questions, many uncertainties, and no authoritative answers. Will you broadly outline the dangers you anticipate?
Well, the dangers largely stem, I think, from the fact that it is an uncharted course. We've had 26 amendments to the Constitution, all produced by proposals from Congress, the alternative, the other route in Article 5. We've never used this one. This route is obviously legitimate, but it is an unknown. And the main danger I see is an undeliberate process which begins with the 30 states which, as of early 79, have asked for a convention, largely assuming they're going to get a convention on, by and large, an up and down vote on a specific proposal to balance the federal budget, by Congress calling a convention somewhat broader than that, which deals with the general subject of fiscal responsibility, which in turn may bring in such things as abortion funding or health finance funding or nuclear power funding, which will then be submitted to a convention, which I think has a very plausible case for taking a broader view still. Convention delegates will be able to claim, I believe, that they represent people, the people who elected them, and that they are entitled under the constitutional scheme to deal with any constitutional issue of major concern to the constituency that's elected them. So that states, quite unthinkingly, quite without consideration of the implications, have started a process which, if it culminates, will be a shock to them, a shock to the country, a process of uncertainty, undeliberate constitution making, the kind of thing which I think would make James Madison turn over in his grave.
Professor Bator, you have written, I am not in favor of having a convention and not in favor of a balanced budget amendment. You also, however, vigorously defend the right of the states and the Congress to limit a convention to issues raised in the petition for a convention. Will you broadly outline your premise?
Well, my principal point is that I disagree very strongly with the argument that is sometimes made that the current movement for a constitutional convention is wholly illegal and illegitimate because it is directed at a specific constitutional grievance rather than being a call for an unlimited general constitutional revision. I think it is wholly legitimate for the states and the Congress acting together to try to create a convention addressing a specific constitutional grievance. The uncertainties of it can't be eliminated, but I think that having such a convention was a major purpose of Article 5. Whether such a convention after the fact can be effectively forced to limit itself is a harder question, but even there on balance, I think the better view is that effective limits can be created by the states and by the Congress.
Professor Burns, the Constitutional Convention is generally called the alternative method of amending, the more traditional being proposal by 2/3 of both Senate and House to be ratified by 3/4 at least of the legislatures of the several states or by conventions in 3/4 thereof. Is there any sense that this was considered the vehicle for amendment of specific issue, while the convention method was meant for unlimited deliberation?
Well, that point has been made by distinguished professors of law, but I must say that I disagree with those distinguished professors of law. They have caused me to go through the records of the Federal Convention of 1787, and I do not see that those records sustain the point they make. The language of the amendment as we know it was essentially worked out on almost the last day of the convention, on September 15, 1787. And the particular thing we're talking about, this alternative mode of amending the Constitution, was the response to an objection by George Mason of Virginia, who said no amendments of the proper kind would ever be obtained by the people if the government should become oppressive. He was making an objection to the proposal as it then existed, which in effect allowed the Congress of the United States only to initiate or to propose amendments, as I recall, both on their own initiative and upon the initiative of the states. But at any rate, it was indeed the Congress of the United States that would propose amendments. And Mason objected to this, saying, I think quite reasonably, that, as I say, no amendments of the proper kind would ever be obtained by the people if the government should become oppressive, which suggests, of course, that he understood the possibility, at least, of the inadequacy of the national government, and that there had to be an alternative mode to deal with the inadequacies. To put it quite simply, if the 1787 convention was called to some extent because of the legitimate concern of people like Madison and Hamilton with the fiscal irresponsibility of the states, and the Constitution of the United States that came out of that convention dealt, I think, quite effectively with that problem of fiscal irresponsibility of the states. Mason, in a sense, foresaw the possibility that there might be fiscal irresponsibility on the part of the national government or other kinds of irresponsibility on the part of the national government, and that some way had to be found in the Constitution to deal with that. So, quite simply, it seems to me quite clear that this alternative mode of amendment was put in the Constitution to deal specifically with, or to deal with specific problems.
All right, Professor Scalia, Richard Rovere in the New Yorker suggested that the convention method of amendment might reinstate segregation and even slavery, throw out much or all of the Bill of Rights, eliminate the 14th Amendment's due process clause, and reverse any Supreme Court decision the members didn't like, and perhaps for good measure, eliminate the Supreme Court itself. Now, what would you anticipate from an unlimited convention?
None of that. I suppose it might even pass a bill of attainder to hang Richard Rovere. All of those things are possible, I suppose. Just as it's possible that the Congress tomorrow might pass a law abolishing Social Security as of the next day, or eliminating Christmas. Sure, such things are possible, remotely possible. I don't have any fear that such proposals as extreme as he's talking about would come out of the Constitutional Convention. Surely, whether that risk is sufficient to cause you to be opposed to a Constitutional Convention depends upon how high you think the risk is and how necessary you think the convention is. If you thought the Congress were not necessary for any other purpose, the risk that it might abolish Social Security would probably be enough to cause you to tell them to go home. So it really comes down to whether you think a constitutional convention is necessary. I think it is necessary for some purposes, and I'm willing to accept what seems to me a minimal risk of intemperate action in order to have that achieved. The reason I feel it's necessary is, I think, the reason the founders put in this alternative method of obtaining a constitutional convention, that the Congress is simply unwilling to give attention to many issues which it knows the people are concerned with, and which issues involve restrictions upon the federal government's own power. I think the founders foresaw that, and they provided this method in order to enable a convention to remedy that. If the only way to get that convention is to take this minimal risk, then I think it is a reasonable risk to be undergone.
Unfortunately, you know, you're not sitting in the state legislatures. I wish you were, and we're talking about the risks. I think if we're talking about what has gone on in 30, or at least 27 or 28 out of 30 state legislatures of this country in the years of 1977, 78, and 79, nobody has talked about the risks. The issue has simply been an up and down vote of, do we want the principle of a balanced budget? And one of the outrageous things about the process, the disturbing things about the irresponsible constitutional process we're seeing is that state legislatures have gotten very close to launching this convention, which I agree in proper circumstances is appropriate, without even thinking about the risk. Instead, they've been told, don't worry about it, you can have a convention which will be an up and down convention. My concern is that we ought not to go into this convention thing on this kind of totally vast inattention, ignorance, misimpression of fact and law that we've been seeing in this.
Well, I agree that would be nice, Jerry, but I don't understand what your solution is. There is no way, it seems to me, short of obtaining action from the Congress itself, which in action is the whole reason for the call for the convention, that matter can be clarified.
Well,
so what troubles me about your position is it's essentially a throwing up of the hands.
No, I don't. I think I've got a solution. First of all, for people like you and me to go around to tell state legislators what they're buying when they buy one of these resolutions, which in fact they haven't known. It in fact has been the case that in recent months, for example, when Montana has faced this, when California has faced this, with some explanation of what's involved, they have had second thoughts. New Hampshire has said yes, Montana and California said no. Another thing that can be done is, and I will join with you about irresponsible action in Congress on this one, another thing is to press Congress to pay some attention to what's going on. Congress has been almost as irresponsible as the state legislatures in not holding hearing on a Constitutional Convention Procedures Act, such as the Irvin-Helms proposal, in pussyfooting around, in acting like the worst kind of technical lawyer, in finding excuses.
But of course...
Now, if Congress... I think Congress can be gotten to make it clear what the states are buying. And that may get us some reconsideration in states, and if the states want to vote for this, they'll at least know what they're doing.
Professor Berto.
There are things that can be done. There are political and legal dynamics that can be mobilized that will minimize the risks. It seems to me that the call of the states for this convention is actuated by concern about a single grouping of issues. I think that Congress, acting responsibly, could provide that the Constitutional Convention should address those issues and no others. Now, it is a matter of doubt whether that restriction is legally effective. But you know, this convention won't be a group of Louis XVI sitting off in Mars somewhere. They too are subject to political dynamics. They too are subject to the forces and the processes of having to worry about their legitimacy. I think the better view on the strict legal question is that there is nothing in Article 5 that prevents the Congress from limiting the Constitutional Convention to the subject that evoked the states to call it. And I think there would be enormous pressure on the convention to stick to that. And I think that it's very unlikely that they will wander all over the reservation.
I think, Paul, that on the legal issue, Congress has a right to specify a subject, but in my view, that specification is a moral exhortation to the convention, creating a presumption that that's what the issue is that started this process around the country, but that a convention then is free to overcome that presumption and to say, in our election, our constituents were interested in two other subjects as well. The fact is they're going to run for election under the Helms and bill. They're going to run for election in various congressional districts. They will respond to concerns about nuclear power, about abortion, about busing, about school prayers, about ERA, about whatever you want to talk about. And you will have a considerable pressure, in my view, to say, look, I know we're supposed to go there mainly to think about fiscal responsibility. We'll do that. We'll throw in a few amendments about abortion and busing and spending of money for that. And while we're at it, we'll talk some about school prayer as well. I think the risk is there.
Let me just, by way of background, note that in 1967, Senator Sam Ervin introduced a bill spelling out in some detail the actual procedures which any constitutional convention would have to follow. It was passed in the Senate, reintroduced, passed in the Senate, but never taken up by the House. And in the year 1979, a dozen years later, Senator Jesse Helms has introduced a very similar bill into the Congress. I just wanted to paint that picture for our audience on television. Would you like to talk to this issue, Professor Burns?
I'd like to say a couple of things at this point, Mr. Daly. In the first place, I think I join all of my colleagues on this panel in hoping that the Congress of the United States becomes responsible here and passes legislation that I think it is entitled to pass, governing certain aspects of this mode of amending the Constitution. For example, I would like to see the Congress pass a statute specifying the form of an application. And I would, if I were advising some member of the Congress, I would say that the form of the application should be as follows. The state, for example, to name my native state, the state of Illinois hereby applies to the Congress of the United States to call a convention for proposing amendments to the Constitution, to the extent possible, in other words, adopting the actual constitutional language in this application. This would resolve one of our difficulties as to what a valid application is, and that, I think, would be a valid application. It might also cause the states some second thoughts if they suspected that the convention, when it is called, may address itself to questions other than the one that is exercising that particular state at that particular time. I also think something could be gained if the Congress were to become responsible finally, and I think it's been irresponsible by avoiding this issue, adopt legislation saying that these applications shall be addressed to particular officers of the House and the Senate, specifying those officers, and then also requiring those particular officers, for example, the Speaker of the House and the President of the Senate, to certify to the states the receipt of those applications. This would, I think, would facilitate this problem of how many applications there are at a particular time, and it would prevent these applications from getting lost in the vast maw of the Congress. Now, if I may expand on this, as I think we may have agreement, and I see Professor Scalia has an objection, so I'll override him quickly. This business about fearing constitutional conventions of the sort that we've never had, I'm apprehensive too. And if the truth has to come out, I am not in favor of this particular kind of constitutional convention, largely because of my apprehensions. On the other hand, if the Congress of the United States is set up as a model for the proper way, as a body that properly engages in amending the Constitution or proposing amendments to the Constitution in a proper way, then I must say that the Congress of the United States is not the model that I would choose. We now have two constitutional amendments, so-called constitutional amendments, floating around the states for their ratification, one of which, the D.C. Amendment, is, in my considered opinion, unconstitutional, and the second of which simply has lapsed as of March sometime this year. What I'm saying is that this extension of the ERA Amendment was unconstitutionally done. And if that's the way the Congress does things, let's try the states.
Well, I'm ready to fight, Walter, on D.C. Amendment and on the ERA, but let me fight with you on something else first. The fight is on the congressional procedures matter. I agree with you to the extent that I think Congress has power and should address itself to such procedural issues in the Ervin and Helms bills as where you have to send the applications to avoid this Mickey Mouse game of two senators of the United States saying we don't understand that we have more than 14 amendment proposals because they weren't addressed to the right people, for God's sake. But I think there's a serious problem with that legislative proposal. The proposal that's now before Congress, which I wish Congress would pay some attention to, includes much more than those procedural things. It provides, for example, that first of all, a state has to specify a subject, which I think is outrageous. I think it would be nice to have a state specify a subject, but if a state wants to have a general convention, surely they ought to be allowed to have that. Secondly, it provides that Congress shall make its guess as to what the general subject is that the states have in mind, and then requires delegates of the convention to take an oath to say that they will not propose or discuss any proposal other than the limitation, which I think is outrageous expansion of congressional powers. It goes on to say that Congress then will turn down any proposal which it considers beyond the call, which I think is of highly questionable validity. A lot of the underpinnings of Senator Ervin's proposal, it's rather strange since they're conservative constitutional interpreters, and of Senator Helms's, is that the broad discretionary powers of Congress that we associate with the Commerce power and the 14th Amendment power somehow apply, the necessary and proper clause, apply to Article 5. I think the least bit of historical understanding, I think we'd all agree, makes it clear that Article 5, the convention route, was specifically designed to minimize the role of Congress and not to give them a lot of discretion. And Congress only has the power to make the minimum provisions for electing delegates, setting up the convention, and then deciding on a mode of ratification, and nothing beyond that.
Professor Bato.
I'd like to see if I can sharpen what seems to me to be ought to be the concern about Professor Gunther's interpretation of Article 5. The central purpose of Article 5, of this provision of Article 5, was to give the states recourse in the event that intransigent central authority simply refuses to do something about what is felt to be a grave constitutional infirmity or shortcoming. Now, grant me by hypothesis that 35 states or 34 states now feel that the Congress has intransigently refused to address what they think is a grave constitutional infirmity, and that is fiscal irresponsibility. Now, Professor Gunther says there is nothing that the states and the people can do about it, absolutely nothing, unless they are willing to take the risk that the processes they set on foot for addressing that infirmity will lead to an institution which is wholly free, legitimately, to reinstitute slavery. Now, I guess most fundamentally what strikes me is that a process of constitutional interpretation that says this is what our Constitution says is very strange, it's bizarre. But of all the possible interpretations, why should we adopt the one that is most uncomfortable and the one that most creates what is clearly unintended mischief? Because the central purpose of the framers was to give the states recourse. And what Professor Gunther says is it's going to be very, very hard for you to have recourse because you are going to create a time bomb, a kind of a doomsday machine, which is utterly without control.
Not at all, Paul. You're using an old law professor's device of reductio ad
old law professor.
I'll come back with an older one. No, I don't think I appreciate the constitutional purpose, 87, of giving the states recourse. I don't think I'm denying the states recourse. If the states believe that the balanced budget is a critical issue they want to have a convention on, yes, they can have that issue discussed. They are not likely to worry, and nor should they worry, about the risk that Mr. Rovia mentions about a provision reinstituting slavery, for the simple reason that any fool would know that around this country there is not now support in 38 states for ratifying an amendment to reinstitute slavery. On the other hand, the states should know that this is a serious business, and the serious business of the convention includes any issue of such magnitude that delegates are likely to be impressed by it, that the people want to have a hearing on it, and that there is a chance that states may ratify it. That isn't that isn't an abolition of the Constitution or a reinstitution of slavery, but that is a broader agenda than the balanced budget itself.
Professor Scalia.
I agree with Paul on what it seems to me the law ought to be, how Article 5 ought to be interpreted. There's no reason not to interpret it in such a fashion that you can have a limited call if that's what the states desire. However, one can say that that's what it ought to be and that that's what it seems to be, but it is very difficult to say that that is absolutely how the convention will behave, which is the only reason that I am willing to acknowledge an iota of truth to Richard Revere's absurdities. I would like to put the whole thing in perspective, though, and tell you why I'm willing to run the risk of those absurdities. I don't think there's any way, and I think Paul would agree, that there's no way to avoid the risk entirely. I think that what he says is the law, but somebody else may think otherwise, and even if it is the law, the convention may ignore it, and once it does ignore it, who knows how that works out. But what's the alternative? The alternative is continuing with a system that provides no means of obtaining a constitutional amendment except through the kindness of the Congress, which has demonstrated that it does not want to have any other way to get a constitutional amendment. It could have cleared up a lot of these questions. It could have facilitated them long ago. For that matter, as was suggested to me by someone before the program, it could have provided an amendment by the normal amending process, which says that limited calls for state conventions are proper. That would have eliminated all doubt. But the Congress is not about to do that. It likes the power. It does not want to have amending power anywhere else. Now, not long ago, Proposition 13 came out of California, and there was a great cheer about the country. That cheer, it seemed to me at the time, and still seems to me, was not so much because of the narrow issue that it pertained to. It was a sort of amazement that, by golly, the people, when they really want something badly enough, can really get it despite the opposition of the legislature at the state level. And I think we're facing the same thing at the federal level. The Congress knows that the people want more fiscal responsibility, but it is unable to provide it. Now, what we need is some means at the federal level, like Proposition 13. The Constitution has provided it. I suggest that if the only way to clarify the law, if the only way to remove us from utter bondage to the Congress is to take what I think to be a minimal risk on this limited convention, then let's take it.
Professor Gunther?
I think one of the things we were talking about earlier illustrates one of the problems. The Helms Bill, as did the Urban Bill, says in at least 3 places, quite consistently, all these issues, all these doubts about the validity of the application, the scope of the convention's discussion shall be decided finally by Congress and shall not be re-examined by any court. Congress is aware of that potential confrontation and tries to head it off by saying there shall be no judicial review. I think there is a risk in that because although there is some precedent to say that some aspects of the amendment process are beyond the court's authority, it is not at all clear that the courts cannot get into it. I suspect the courts and the present Supreme Court would be perfectly happy to stay out of it, and everybody else is getting bruised. Why should they be? But I think there is a potential confrontation there because Congress may be aggravating that risk by trying to say keep out, and the courts may well say that is an improper restriction on court jurisdiction.
Professor Burns.
I somehow find it strange that one of the most important aspects of the Constitution, namely the mode of amending the Constitution, should not be subject to rules of constitutional law. Now, that statement immediately needs qualification, but it stems largely from a Supreme Court decision of now some 40 years of age, in which the court has come very close to saying that the issues that arise in this business are political issues and not justiciable issues. 4 members of the court, led by a very famous Supreme Court justice, Justice Frankfurter, took the whole step and went so far as to say that all of these issues should be regarded as political. I find that unacceptable, because I think that this is something that requires constitutional law, and constitutional law is determined in the way in which we traditionally do these things in the United States. So I, in a sense, would favor legislation. I would favor, if nothing else was involved, I would favor a convention in order to get some of these things clarified, in order to get cases before the courts, in order to have the solemn word of the Supreme Court of the United States with respect to these very important issues. They are justiciable issues, I think. And since that decision to which I've referred, Coleman v. Miller, 40 years ago, there have been developments, of course. We've had cases in which the Speaker of the House of Representatives himself has been the defendant in the suit, and why not the current Speaker of the House a defendant in a suit? We've had United States against Nixon, in which the President of the United States has been shown to be amenable to judicial process, contrary to a post-Civil War decision, Mississippi versus Johnson. So there have indeed been developments in this area, and it seems to me that it's entirely possible that the court will reverse itself on this judicial, of this political question business, and I think it would be salutary to have some constitutional law coming out of the Supreme Court of the United States on these questions.
I don't mind the court getting into this, but I do want to object to the impression that there ain't no constitutional law unless the court talks. We're talking about constitutional law, and there are a number of authoritative, although not nearly as final voices as the Supreme Court.
Just put me down for objecting to the court getting into it. It seems to me that this is not one of the areas where I think the court can have a whole lot to contribute.
Why is that?
And indeed, well,
is it not possible that the court, being detached from the political issues, in principle at least, is the
well,
body
but it isn't
best?
in principle. I've talked about the need for a convention because somehow the federal legislature has gotten out of our control, and there's nothing we can do about it. One can say the same thing about the federal judiciary. And that's one reason I'm willing to take the chance, in order to have a convention, take the chance of some doubts that now exist. I'm not sure how much longer we have. I am not sure how long a people can accommodate itself to directives from a legislature that it feels is no longer responsive, and to directives from a life tenure judiciary that was never meant to be responsive, without ultimately losing its sense of control of its own destiny. For example, it utterly amazes me that the very important issue decided as one of a constitutional law, which is about to be decided by the Supreme Court, to wit, affirmative action. We are all sitting breathless, waiting for the Supreme Court to tell us what our fundamental beliefs are with respect to this particular issue, without having a hope of getting anything done about it if the Supreme Court should find that our fundamental beliefs are in fact different from what our fundamental beliefs are. We have no recourse. There's not a whit of a chance that the Congress will overturn any decision that the Supreme Court comes down with in the Weber case. And unless this alternative method of amending the Constitution is adopted, we will continue to live under that kind of what I consider inanely non-democratic system. It is just foolish to sit wringing one's hands, wondering what the Supreme Court is going to tell us our fundamental Constitution requires on an issue such as this. And that's what we're condemned with, unless Jerry, you can screw up your courage and say, let's throw the dice.
So the issue really is what,
Only if you can guarantee.
how desperate our condition is. That's really the situation.
Only if you can guarantee I'll be a delegate. I've always wanted to be James Madison. And I'm ineligible to be president, as is Paul.
Professor Burns, did you want to? Well, that opens up all kinds of questions. Who will be the delegates? Who will pay them? They were not paid, in a sense, in 1787. They were reimbursed by their particular states. The Constitutional Convention itself passed a resolution calling upon the Congress, at that time the Continental Congress, to pay the officers of the convention, Mr. Jackson, who was the secretary, and I presume they also included those sentries who prevented the people from interrupting the procedures of the convention. But who will pay, and will television be there in 1984, a year I choose by random?
That's perhaps where we can get the financing for it.
I'm sure the Congress would be happy to pass an equivalent to the federal election campaign law. You can have PACs, you know, contributions from PACs and campaign limitations. It'll be beautiful.
No, but quite seriously, you know, if you consider the situation that prevailed in 1787 when these people did what I suppose everybody in this room knows they did in order to promote the atmosphere of a very solemn convention, a very deliberative convention, keeping, of course, the press out, to say nothing of the modern means of the press out, having the cobblestones around the hall covered with inches of dirt. Who paid for that, I don't know.
Not much was necessary.
Yeah.
It was Philadelphia, after all.
covered with dirt in order to muffle the sounds of the horses' hoofs and the wagon wheels on the cobblestones, in order to promote calm and sensible deliberation and so forth. Everything being done in order to allow these particular people, who truly were an extraordinary body of men, to deliberate and to decide upon a proposed constitution. It had no validity, of course, until it came out of the people in their ratification. But can we possibly reproduce this with Jefferson? I tend to believe from the end of this war, and it's a sobering thing to realize he was talking about the Revolutionary War, we shall be going downhill. And
Walter, I have two responses to that. One is we won't get Madison and Hamilton, the caliber of people will not match them. But on the other hand, they will be people with 200 years worth of experience in the existing Constitution to look at. Now, you know, you trade a little bit of smarts for a little bit of experience. I think it's likely to come out. It's likely to come out close to as well. And the second point I want to make, and this goes to the risk question. It isn't though we have had a sacrosanct, untouched Constitution. The Constitution has been changed, whether we have liked it or not, over the last 200 years, and not merely by the ratification process. Many of the decisions of the Supreme Court have made fundamental alterations, which we've never had any occasion to say we like or we don't like. So it isn't a matter of whether we leave the Constitution untouched, but whether we, in a sense, prevent somebody else from touching it in a way that we don't like.
Professor Bethel.
The last point made, that the Supreme Court has made controversial decisions, reminds me that on this issue of whether there should be judicial review, that is, whether Professor Burns is right that the Supreme Court should step in and itself resolve these ambiguities and uncertainties as to the meaning of Article 5. One reason I think that we would be better off if the Supreme Court stayed out of this and kept to its decision that these are all political issues and non-justiciable. It's really one of the few areas where it is still the case that the Supreme Court has said that it will actually stay out of something.
treasure that precedent.
One thing that counsel's keeping to that is that the Supreme Court and its decisions may be protagonists in this drama. That is, the intransigent central authority that may be in the process of being resisted in a given case is an interpretation of the Constitution given by the Supreme Court. That happens not to be the case on the balanced budget amendment. And I think it's very troublesome to think of the court as being the final arbiters of the powers of a convention, which is called in response to a feeling that the court has given us a constitution that we don't like. So on the whole, I think that by far the happier prospect, and a not impossible prospect, is that with a certain constitutional spirit of trying to work one's way through these ambiguities, that no litigation will be necessary.
With your permission, I will consider we have put down a very broad base for what should be an interesting question and answer session. So let us go to that question and answer session now. Yes, sir.
Yes, my name is Don Bandler, and I'm with the Carnegie Endowment. My question is first for Professor Scalia and then to the panel. You expressed some doubt about whether the American polity and its normal institutions would be able to handle and contain the political passions of the American people. And yet, it seems to me that we're in a time where there's increasing impact and power of single-issue lobbies. You also alluded to that. We recently celebrated the 25th anniversary of Brown versus Board of Education. We got through the Vietnam War with some stretching, but no fundamental changes or constitutional changes in institutions. What is it that's so special, so extraordinary about the issues that you think would be good for constitutional conventions, the budget issue, abortion, that requires this extraordinary remedy?
Those, I listed first among my the things I would like to have considered structural issues at the federal level. I don't have a lack of trust in the American people. I mean, you know, I'm the one up here who's least terrified of a convention. Yeah, we've come a long way. We've gotten over a lot of problems, but the fact remains that there is a widespread, deep feeling of powerlessness in the country. One sees it on every side with respect to many issues, not just the budget issues. The people do not feel that their wishes are observed. They're heard, but they're not observed, particularly at the federal level. Now, the Congress has come up with a lot of palliatives for this problem, among which I was on a panel a few days ago discussing the legislative veto, for example, which to my mind doesn't solve the problem at all. The basic problem is simply that the Congress has become professionalized. It has an interest much higher than ever existed before in remaining in office. It has a bureaucracy that is serving it. It is much more subject to the power of individualized pressure groups as opposed to the unorganized feelings of the majority of the citizens. All of these reasons have created this feeling, which is real and which I think has a proper basis, of powerlessness. One remedy for that, the one specifically provided in the Constitution, is this amendment process which bypasses the Congress. I would like to see that amendment process used just once at first. I don't much care what it's used for the first time. I think just having it used once will exert an enormous influence upon both the Congress and the Supreme Court, I think. I think we'll get the parameters established of how you do it, what can be done, and I think after that the Congress and the court will behave much better.
Anybody else wish to go to this question?
Well, I can't help saying that is part of a concern about it. Try it once and we'll blast the way for a lot of other single issues to come along. Sure, if there is that thoughtful, widespread concern about that in the country, 15 conventions on 15 issues are not a horror. On the other hand, I know groups who are just waiting in the wings for hoping that the balanced budget issue in its narrowest form is called for convention so they can present their narrow proposals. Now, what's wrong with that? What's wrong with that is that in terms of the solemnity and seriousness of the process, there is a trivializing that begins to set in that way. I mean, sure, if they're limited to the kind of issues, some of the kinds of issues, maybe some of the kinds of issues you would want to present, you know, fine. But there is, together with the benefit of giving reality to this alternative route, the risk of unseriousness, unsolemn, trivial changes.
Professor Battle.
Well, it's been kind of fun to careen along on Professor Scalia's bandwagon for quite a long time, but I've just
You're getting
fallen
off. I sense it. I sense it. It's too bad, Paul.
I'm not getting off. I just fell off.
Hallelujah.
Because I do think that really we ought to have a constitutional convention only if there are before us proposals which we think are wise proposals. And just to have a constitutional convention sort of to prove the point that we can do it. And because we feel powerless, and not really to have any kind of considered issue framing and addressing of specific proposals and worrying about whether this is a good amendment. That strikes me as slightly crazy.
I'm glad
so
Paul,
that's
you
why
reconsidered and kept it moderate.
I wish you had said that without pausing. I don't mind you saying crazy, but it's the pause and then saying slightly, searching for the right word.
You know, the bottom line for me has been that the simple reason I'm against a constitutional convention is because I haven't been persuaded that the balanced budget proposal or the various alternatives so far proposed would be a wise thing for us to adopt. And that really is, I think the issues are substantive. I keep fighting for keeping the avenue, that is, I'm with Nino in saying this is a terribly important structural feature which protects our liberties, this Article 5. And that I really believe in. But then let's use it for some purpose that strikes us as a wise constitutional purpose.
May I rehabilitate myself, maybe reach down a hand to pull Paul back up on the bandwagon? When I say I don't much care what it's about, I mean among various respectable issues for a constitutional convention, I am relatively neutral as to which of those goes through the first time. I think it's much more important that the process be used for one of these important issues that concerns the American people than it is which one of those issues, or than it is whether the convention might get into something else. Sure, I wouldn't want a convention for some silly purpose, of course not. But I think there are a lot of serious purposes around, a lot of matters that profoundly concern the American people, and as to which they can't have any voice. I really want to see the process used responsibly on a serious issue, so that the shibboleth, the Richard Rovere nonsense about the end of the world is coming, can be put to rest, and we can learn how to use the process responsibly in the future.
Next question, please.
Yes, my name is Austin Ranney, the American Enterprise Institute. Let me begin by saying that I'm amazed that in this discussion we've heard all sorts of comments about uncharted voyages into uncharted seas, no experience, nobody knows, we're just guessing. Fact is, we've had over 200 constitutional conventions in this country since its origin. Now, to be sure, all but one have taken place at the state level, and you may say, well, that doesn't really matter, and it is no analogy, no experience we ought to look to. It strikes me, though, that perhaps there is some experience there, and if there is, I would like to know what, if anything, you think that tells us about what might happen nationally. Also, I would like to say, and this is my specific question that I'm addressing to both Professors Gunther and Scalia, that really everything that you've said about really horrible things happening that might happen of the Rovere variety, or marvelous things that might happen of the Scalia variety, depend a good deal upon the kind of people who get elected to the convention. Now, one thing we do know from this so far unmentioned state experience is that elections of delegates to state constitutional conventions have very low turnouts, 15, 16, 18%. Now, let's say that in a national election we have a huge turnout, 22, 23, 24%. Remember, we turn out barely half of the electorate even for a presidential election, and now about a third for congressional elections. It's extremely unlikely that we would have more than 20 or 25% of the voters out. And I would like to know from both Jerry Gunther and Nino Scalia what kind of people they think on a low turnout would be elected, and whether they think those people would do the good things they would like to see or the bad things they fear.
Since this is likely to be not a continuing process, it's a one-shot election, that there'll be a competition among issues, it is as likely that the people who want to ban nuclear power and who want to have new establishment of minority rights and new responsibilities for the federal government and who want to mandate health insurance, or the people you wouldn't like, Nino, would come along. And I think it is entirely foolhardy to make one's guesses in this very risk-prone business on the basis of who is likely to be elected in a set of elections which will be simply elections of delegates to a constitutional convention 6 months or a year or 2 years from now.
It does depend, I think, to some extent on the method of election. If the delegates from a particular state are to be elected at large, then one can anticipate one thing probably. If we follow the provision of the various say the Helms bill and so forth, it's not likely to be that way. It's a kind of single-member constituency business, and then I suppose we really will turn on various single-issue groups proposing candidates, and some single-issue groups, pro-lifers winning in one constituency, and I can't say anti-lifers winning in another constituency. And that, of course, is not the sort of constitutional convention that one would like to contemplate. If the convention itself is to be a deliberative convention, these various delegates may not be bound by their instructions from the states or something, but they'll be bound by their instructions from their particular groups. That's a reason to be apprehensive, you know.
Well, you know, you can make the same arguments about the next congressional election. What kind of people would be elected to the Congress? It's the same election. Whenever you go for election, you can. It's another one of the horribles that's trotted forward. I do agree with one thing, that the kind of person, maybe I'm not agreeing with it, I'm saying it. I'll say it and then agree with it. The kind of person who is elected undoubtedly will depend to some extent upon what it is thought the convention will deal with. And that's one reason that I share Professor Gunther's concern about the process, which makes it clear going in what the convention is going to deal with. If it is just going to deal with a single amendment, let's say it's the financial responsibility issue, I think you might expect, indeed, some economists as well as political scientists and lawyers to be elected. On the other hand, if it is going to be a much broader convention, if it is to get into other issues, I think the people would probably elect quite different people as their representatives. And I don't think that they're as stupid as one makes out, and are going to elect somebody that cannot do an adequate job simply because on one particular issue, if that is not the only issue up, they happen to agree with them. If that is the only issue up, then what's wrong with it?
Well, beyond offering myself as a candidate for a post as a delegate, providing either the states or the federal government provide some emolument, this concludes another Public Policy Forum presented by the American Enterprise Institute for Public Policy Research. On behalf of AEI, our hearty thanks to the distinguished and expert panelists, Professor Walter Burns, Professor Gerald Gunther, Professor Paul M. Bator, and Professor Antonin Scalia, and also our thanks to our guests and experts in the audience for their participation.
This Public Policy Forum on a Constitutional Convention has been presented by the American Enterprise Institute. It has brought you the views of 4 experts in the field. It is the aim of AEI to illuminate important issues of the day by presenting many viewpoints, in the hope that by so doing, those who wish to learn about the decision-making process will benefit from such a free exchange of informed and enlightened opinion. I'm Peter Hackus in Washington.
This Public Policy Forum series is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C. For a transcript of this program, send $3.75 to the American Enterprise Institute, 1150 17th Street Northwest, Washington, D.C. 20036.